Booty a softball question coming up, expecting Booty to have a reasonable position which will pacify the justices who have some doubt about the sheriff's position here. And Booty, being an honest lawyer and an advocate of great integrity, doesn't take the bait and gives Rehnquist an honest answer that Rehnquist wasn't looking for.
These of the sheriff's office. Are these designed to cover the situation, supposing a riot had broken out in the jail or some event of particular newsworthiness? Would these regulations have necessarily governed press or public access under those circumstances?
Yes, it would. There's nothing in the record in any case, Your Honor, to indicate any alternative means to these. And as I say, I'm not finished, but this access package taken as a whole is the entire package. That completes, Your Honors, the access that exists. The complaint of KQED with respect to this is that there is no random interviews on the tours, that no inmates are on view for their cameras in cells or barracks or eating for televising, and that there is no access on demand for their equipment. As I have just indicated, there is access with their equipment on a scheduled basis, but not on demand. The district court did not make any finding of any intention to conceal conditions in the jail. But nevertheless, the district court made its injunction, which requires the sheriff to allow what it called full and accurate news coverage, and specifically required the sheriff to permit random interviews on the tours, and to permit the use of cameras and tapes, and plainly not on the scheduled tour, but on a demand tour. The only exception stated in the district court's memorandum and injunction was that when tensions in fact existed, the sheriff would put a stop to the access. In fact, the district court virtually invited litigation on the point because it says if anybody thinks there really isn't tension, they can come in and we'll have a hearing on that. So what the district court did then is it balanced the asserted media needs against the sheriff's public access program. There was no balancing by the district court of the public's rights in any way. The district court did not address the public rights in any way.
When you say the public right, are you talking about some term that has meaning in constitutional law?
Yes, I think I am. I think the public does have some rights of access.
Is the sheriff of Alameda County an elected official?
Yes, Your Honor, he is.
And I presume if the public in Alameda County thought they weren't getting enough access, they could vote against him in the next election.
No question about it.
And what other right of access does the public have?
How does one...
I mean, under the decided cases of this court.
Well, that's...
Under the Constitution of the United States.
As interpreted by this court, which may be a different question.
Well, it's not entirely clear. In the Pell case, what the court did, as I read it in any case, is the court found that there was no intention to conceal any conditions. The court found that there was public access, and that was enough. Those two factors. There was plainly nothing being swept under the rug, nothing being hidden. At least the court determined that the public access was there adequate. That was the statement of the court. Now I appreciate, and the reason I hesitate, Mr. Justice Rehnquist, I appreciate that the public access in that case was not, strictly speaking, an issue, just as it was not placed an issue here.
Wasn't Pell really a decision that said whatever the public access is, the media access need be no greater?
Indeed, that's exactly what the court said. But I don't read the decision as saying that means necessarily that the public access is zero. That's not resolved in any decision of this court that I'm aware of. It wasn't placed an issue in that case. That's my point.
Well, more specifically, Mr. Wood, you don't seriously contend that the whole problem could be solved by having zero access to public and press both.
Why don't you? Well, that isn't...
That's a perfectly logical position to take.
Well, it is...
But it's a correct position.
Yes, it is a logical position, Your Honors, but it is in our position. There's no... I'm not convinced, and I, considering the body that I'm speaking to, I'm not convinced that's what the court held in Pell.
What the court held in Pell was, as I understood it in writing it, was that the press had no right of access superior to that of the general public.
Absolutely. No question about it.
It didn't deal with whether or not the general public had any right whatsoever under the Constitution, the First and 14th Amendment, or any other provisions of that document.
That's exactly my position, too, Your Honor. It wasn't...
Well, this doesn't sound good. Stewart is the key vote, and he's seemingly taking the position that it's perfectly logical to have zero access to the jail as long as there's equality between press and public. So I hope you've thought up a good argument to convince Stewart that that's not the way the case should be approached, and it should be decided in favor of the press and the public. That's Booty's argument, what you've heard. Then it's customary it's the script when you stand up to address the court that you say, Mr. Chief Justice, and may it please the court, and then you get a chance to sort of lay out some of the facts or what you say the issues are, what your introduction to your argument before you get interrupted. But I didn't. Justice Berger interrupted me before I got a word out of my mouth.
Mr. Turner? Mr. Chief Justice, may I please say about this? Well, first off, an individual who walks in on the day when the press has a scheduled tour and says, I have a camera, I'm an amateur photographer, and I want to go along. Do you think the sheriff can exclude that private citizen? First off, I'd like to correct the state of the evidence. The sheriff has never toured for the press. There's nothing in the record to support it. All he said, when it became clear at the evidentiary hearing in this case, is that he would be willing, if the court was going to grant preliminary injunctive relief, to live with a special tour for the press, in which they could bring their cameras and do their business in that way. He has never implemented that offer. And in context, that offer was only to be carried out if the district court was going to order him to do anything more than he was otherwise willing to do. Do you think as a matter of prison or jail administration, the director or sheriff could say, it's more convenient to keep these two categories separate, that it will have general public visitation on the first Monday in every month, and we'll have media representatives on the second Monday of every month? I think it is permissible for an administrator of a jail or prison. Any constitutional question involved in that kind of a decision? Or is that just routine administration of the institution? A constitutional question arises when, as in this case, the sheriff limits access by reporters either to zero, as before this case was filed, or to these antiseptic guided tours that he initiated right after we filed suit. There's a constitutional issue. Well, if he gives the media precisely and exactly the same access as the public, do you think there's any constitutional problem involved? I do, if that access is zero, or if the access is not reasonably sufficient to prevent concealment of conditions in the jail. Then we would have a situation, as they have in South Africa, where the press
is effectively precluded from reporting on jail and prison conditions.
What part of the Constitution do you draw on to say that there is a right of access to take pictures and do these things?
Well, this is a First Amendment case. I think it would trivialize the First Amendment to say that it requires specific things like a particular number of days a week, or photographs, or random interviews as opposed to full interviews with individuals and so on. I don't think that's what the First Amendment does. What the First Amendment does is prohibit a government official from unjustifiably interfering with the acquisition of information for publication. And that's what this case is about.
Well, when you say unjustifiably interfering with acquisition of information for publication, then it is a justiciable question in every case, whether, for instance, the Supreme Court of the United States excludes the press from its conferences, or whether the Federal Aviation Administration excludes the press from its executive sessions.
Well, I don't know about just justiciable.
Well, under your test, at any rate, it's something that's subject to constitutional inquiry by a court that can decide constitutional questions, whether the decision of any governmental official to exclude the press from any part of the public domain is, under his control, is, quote, justifiable.
This is another phenomenon that you encounter in Supreme Court adjudication. The court always wants to know that they're not about to open the floodgates and be inundated with cases if they adopt your theory of the case. In this case, if they announce that there's a First Amendment right of access to jails, then surely there's a First Amendment right of access to lots of other non-secure government facilities and government information, and down the slippery slope, so that every time a government bureaucrat says, no, you can't come in, no, I'm not going to show you that, there's a constitutional case. There's a new litigation opportunity opened up every time a government official says no. And Rehnquist is voicing the concern about, if we go your way, aren't we going to be flooded with litigation that will overwhelm our system? So you better think up a good argument for why they shouldn't be worried about that.
Yes, that's our position. Our position, of course, is not that the press is entitled to sit in on conferences of this court, any administrative agency, and so on.
Only because that's a justifiable decision on the part.
Yes, and the information has some claim to confidentiality.
But in each case, you could go into the United States District Court, or whatever district you want to, and under 1331, argue a constitutional question as to whether or not the decision of the particular agency was justifiable.
Theoretically, yes, but in fact, there aren't any other agencies that we're aware of that treats information the way the sheriff does. The evidence in this case shows that the jails and prisons in the area are completely open to the press, and they may enter and go into the maximum security sections, talk with prisoners, interview prisoners, take pictures, whatever they want to do. Those are the institutions where one would assume public access is rather limited.
Let's suppose the president decides to have cabinet meetings open to the media with television and all the other incidents. Does that mean that the courts have to open their conferences because someone else does it?
No, of course not.
Well, then what significance is it that some other prisons in this area have different practice?
Because it shows how unjustifiable the sheriff's practice is. The only feasible way that the public at large will know what's going on in this jail is if reporters are allowed in. A handful of people can go on the tours, but reporters, acting as agent for the public at large, the eyes and ears of the public at large, can go in and without any disruption to jail routine, because it's done routinely in all of the other jails and prisons in the area, can meet this public need without interfering with any valid purpose of the sheriff.
What would you say?
Now, the sheriff, in answering why shouldn't reporters be allowed to do their job, the same job done in other jails and prisons in the area, points to the court's decisions in Pell and Saxby. And his core position is that all he needs to do is provide equality of access. Not access, but equality is the way he reads those decisions.
How do you read them?
We think that the whole assumption of the Pell and Saxby decisions is that there be reasonably sufficient access to prevent concealment of conditions. If there is that, then equality is fine. We don't claim any superior rights for the press.
Well, you do claim, I suppose, you can reasonably claim that even though the right of access of the communications media is no greater than that of the general public, that perhaps because of the technical needs of the communications media, the equality needs to be provided in a different kind of way. In other words, let's say that there's a right under the existing rules and regulations, the public can go through the certain rooms of the White House within certain hours every day. Well, the press couldn't set up its television cameras then there and interfere, then they each would be interfering with each other. Certainly there's an equivalent availability to the communications media of the same sort of public access to those rooms in the White House that are open to the public. But that might require special arrangements for you to make to set up your television cameras or something else an hour when the public, in fact, is not there.
Yes.
Just in order to preserve.
Exactly. We have no quarrel with the court's holdings in Pell and Saxby. There was rather full access there. Reporters could enter the institutions, go to the maximum security sections, talk with prisoners they randomly encountered, take photographs. The only thing they couldn't do, the only purpose for which access was denied, was to single out individual prisoners and make media heroes out of them, have them interviewed, have them come to public attention. The evidence in that case was that indeed created security problems. The court upheld that narrow restriction on access, but there was certainly sufficient access to prevent concealment of conditions in that prison. And we don't have any quarrel either with the broad no greater access statement of the court in those cases, provided that it's understood that there is sufficient access to prevent concealment.
Well, how far does your argument go? There are many areas when you agree that to which the public does not in fact have access. Let's say to the Oval Office in the White House.
Yes.
No general right of access by the general public at any time during the 24 hours of each day of a 7-night-day week. And to that extent, there's no access period. Now, to that extent, the public doesn't know what goes on there.
That's right.
It knows only through press officers at the White House. And yet, does that mean that for some reason or another, the fact that the public isn't admitted at all, that the press then must be?
No.
Well, then what is your argument?
Well,
let's assume in this particular county jail, the public was not admitted at all, except in terms of the general public. Members of the families were, and lawyers were, and doctors were. But the general public, no. By that very fact, does the press then gain access? That seems to be your argument.
Yes, it is.
Well, I don't understand that.
Well, that was the situation before this case was filed.
Yes,
not only was the
we're
public...
talking not about policy or prudential considerations or wisdom or lack of it. We're talking about what is required by the First and 14th Amendments.
Yes.
Else this case shouldn't be here.
That's right.
And why then does the mere fact that the public does not have access thereby confer a right upon the press to access? That's a brand new doctrine that I've never heard of.
if both press and public were wholly excluded, as they were before this case was filed.
And as they are from many areas of public life, of governmental life. They're excluded from the war room over in the Pentagon, I assume.
Indeed, it should be.
Various parts of the CIA, as has been pointed out, something else.
The difference between those kinds of closed institutions and this one are two. First, the information which is being discussed in the CIA and various government agencies which you've mentioned is information that properly should not be made public. While here, what's going on in this jail is information that has no claim to confidentiality.
How do you know what should be properly made public and what has no claim to confidentiality under the First and 14th Amendments?
Well, there's no claim at all by the sheriff that anything that happens in this jail should be held secret from the public.
Well, but you have to make out your claim under the First and 14th Amendments of the Constitution. So when you say that something has no claim to confidentiality, that must be a part of the First and 14th Amendments. Otherwise, you can't prevail.
Well, what I'm saying is that we don't seek access to information that has any claim to confidentiality.
Well, there may be other reasons that the public is not given access, aside from confidentiality. The reasons of security, of discipline, of the very fact that a jail is a jail.
Indeed, to the extent there's a governmental interest.
A commander of a military station could certainly keep members of the public out of observing certain troop activities, I assume.
Yes, of course. When there's a governmental interest.
Confidentiality, just
yes,
discipline,
well, of course,
training the troops.
We concede that. We believe that the proper test is the one that this court used in Martinez before that in O'Brien, where there is a governmental interest, whether the interest is confidentiality of the information, or security problems, or some other important governmental interest. Of course, access can be denied.
Maybe part of the punitive policy of a particular governmental agency might be that in this jail you're not going to have members of the general public around. This is a maximum security institution, and one of the conditions in this jail is that you're not going to be able to associate even peripherally with members of the general public. Why wouldn't that be a perfectly legitimate governmental interest?
Well, it may be, but this sheriff has never advanced that consideration. He certainly
He
doesn't.
doesn't have to. He doesn't. It's you who are attacking what he's done.
That's right.
You who are saying what he's done is unconstitutional, violative of the United States Constitution.
And that's
he doesn't
because
have to justify it. You have to invalidate it.
The district court invalidated it because it found that the interests advanced by the sheriff were, though important, the means of exclusion that he used were not necessary to serve any of his interests. Of course, if access has to be denied during an emergency, no question about it, that's built into the district court's order. All the district court said is reasonable times. We see that as meaning on reasonable notice. And the sheriff may completely refuse access at any time when he thinks, in his discretion, according to the district court's order, tensions in the jail would authorize him to close it down.
Mr. Turner, in answer to Mr. Justice Stewart's question about the difference between what you claim your rights are here and the interest in finding out what happens in governmental conferences where there's secrecy, like you said, there are two differences. There's an absence of interest in confidentiality here, and there is an interest in confidentiality in these other cases, but you never got to your second.
The second one is that this is an institution whose purpose is the involuntary confinement of people, with an opportunity for overreaching of liberties of the people who are involuntarily confined, and very little opportunity for that to come to public knowledge unless reporters are permitted in.
Don't each of those people have a right of access to a lawyer?
Well, some would be represented by the public defender if they are pretrial detainees. The other half of the prisoners who are convicted and serving misdemeanor sentences or short felony terms do not, as I understand it, have a right to counsel.
But hasn't this court held they have right of access to court at any rate?
Yes. Oh, of course, and they could mail off to the court a writ of habeas corpus. But that's not a way of bringing to public attention the sheriff's stewardship of this facility.
Well, it seems, why isn't it?
Well, it might, if the writ were heard
It might be a very appropriate way of doing precisely that.
on the evidence. But that's just not what happens when prisoners file these writs. They don't hold a plenary hearing inquiring into conditions. Probably 99% of the writs are denied summarily with no hearing at all.
And they're filed in the court and matters of public record available to the press, aren't they?
Yes, they would be.
Is there anything to prevent every prisoner in the institution, whether a pretrial detainee or under a conviction, from writing a long, long letter to his wife or his mother or his lawyer and having that published in the letters to the editor?
Well, the sheriff doesn't prevent it. What prevents it is the responsibility of journalism. They are not going to print unsubstantiated information received from a prisoner, whether by letter or otherwise, without an opportunity to verify the allegations made by the prisoner. That's what's missing here. Can't go in, the prisoner says there's been a terrible fire in the next cell and somebody's been badly injured. Nobody can get in to find that out.
Can't you go in to interview him on a particular day?
Well, you can visit a sentenced prisoner during the 3-hour visiting period on Sundays.
Couldn't you verify or corroborate his story or further develop it in such an interview?
Yes, but you could not see the scene. You have no idea what the conditions look like. Should the press take the prisoner's word for what it looks like and what happened without checking it out? I think not. And certainly my client thinks not.
Well, should the press take the president's press secretary's word for what the president's views are without going to the Oval Office and checking him out?
Well, that's the way they do business over there.
Oh, this is the way they do business now.
We're dealing here with a constitutional issue.
The President of the United States cannot be required to meet the press by any constitution.
How about a United States senator? How about a United States senator? There are normally 100 of them.
No, I don't think any court could order a senator to sit down and meet with the press.
435 members of the House.
We're not trying to use the First Amendment as a Freedom of Information Act. We're not saying the sheriff has to come out and meet the press, or open his files, or tell us when anything happened. He just can't shut the door to us on the ground that all that's required is equality, even if that equality is zero.
Well, it gets worse. Believe it or not.